Good morning, everybody. My name is Lino Lorenzo. I'm a principal associate in our commercial disputes and restructuring insolvency team. I'm joined today by Paul Knight, a partner in our commercial team. Today we're going to talk to you about the Corporate Insolvency and Governance Act, and in particular how the recent changes to the insolvency legislation in this country impacts your businesses and your dealings with parties in financial distress. We're going to talk a bit about the outline of the new insolvency procedures that have been introduced. I'm also going to cover a bit of an explanation of the restrictions that on termination rights that have been brought in as a result of these changes. And then Paul is going to talk to you about what drafting options and practical steps that you can take to deal with some of the issues that come up today. A bit of housekeeping. We are recording this webinar so that you'll be able to access it after the event. If you want to ask us a question, please do so. You can ask questions for us in the question and answer box on your screen. Why am I talking to you about the Corporate Insolvency and Governance Act at all? Well, it's a big deal. This is probably the biggest change to the UK's insolvency and restructuring legislation for the last 20 years. Colin Haig, the president of R3, which is the main trade organisation for insolvency practitioners and other insolvency trade bodies, said that hopefully the bill will support the profession's efforts to help businesses navigate the economic damage caused by the pandemic. It does rather more than that, because what the Act actually does is it brings in a number of changes designed to cushion businesses in light of the pandemic, but it also brings in a number of new insolvency processes as well. And a significant change that has come about is a restriction on supplier termination rights, which is not something that we've seen before in this country at all. It's had something of an interesting timeline. There have been some discussions about changing the insolvency framework for some time, going back to a consultation back in 2016, but the bill itself was only actually published on the 20th of May 2020, and it was rushed through both houses of Parliament, and it came into force on the 26th of June 2020, so it's not had very much parliamentary scrutiny, and because of that we still don't really know whether there are likely to be gaps in the way that the legislation works, and some of the legislation in fact operates retrospectively, which is very unusual. So everyone's still finding their way around how this is going to work in practice. The first change I'm going to talk to you about is one of the major restrictions which has come in, which has all been to do with making sure that aggressive debt collection is basically off limits. Quite a common thing that you would see in relation to debts that have fallen due is that you might either decide you want to serve a statutory demand as a precursor to presenting a winding up petition, or you might choose to threaten a winding up petition as a way of making sure that your debts are collected in. One of the things that's been brought in is that any statutory demand that's served between the 1st of March and the 30th of September this year will be ineffective. It will still be possible to present winding up petitions, but there is now an additional condition that a creditor has to be able to show if they are going to present one, and they have to have reasonable grounds for believing that the pandemic hasn't had a financial effect on the company, or that the facts or the relevant grounds would have existed even if it had. That's actually quite difficult to show, because in relation to many companies, it's probably not that likely that you will have very much information about what financial effect that the pandemic has actually had. And even if you're chasing a debt which had been outstanding for some time, the very fact that the debt may have predated the pandemic doesn't necessarily mean that the grounds may not have existed anyway. For instance, if a debtor turns around and says, well, I only can't pay because I'm currently not trading, or my parent isn't able to provide me with the funds that I needed because it stopped trading because of the pandemic. The courts have already showed a willingness to really tighten up on this. And even before the Act came into force, there was a reported decision where a creditor presented a winding up petition against a high street retailer where the shop had closed. And despite the fact the bill hadn't actually been passed at that point, the court was quite happy to grant an injunction to restrain the presentation of that winding up petition, because the retailer was able to provide evidence that the closure of its business was having a significant financial effect on its company. Obviously, that change originally, when it was talked about in the press, was largely directed at landlords, not chasing tenants for their rent, but it's not restricted to that. It's any debt that's due under any circumstance. And even if it is possible, to present a winding up petition, there are now so many hurdles to having a petition heard. It's likely to take even, potentially 3 to 4 months for a petition to get to a stage where a winding up order might be made. So in practical, for all intents and purposes, it is very difficult to use this as an effective debt collection tool anymore. Certainly not at least until the 30th of September or after that. A second change that was brought in also to deal with the pandemic was the so-called suspension on wrongful trading. Now, wrongful trading is a claim that can be brought by which can be brought by a liquidator if he considers that a company or a director basically allowed the company to trade beyond the point at which they ought to have realised that it couldn't avoid insolvent liquidation. What has been introduced here is that for the purposes of determining whether or not that test is met, there's going to be an assumption that the director isn't responsible for the worsening of the company's financial position between the 1st of March 2020 and the 30th of September 2020. And the idea behind that was because there was so much uncertainty about and there still is so much uncertainty about what's likely to happen at the minute, that taking away the threat of a wrongful trading claim hopefully would allow directors to make decisions without risk of being criticised that they might be trading or they might be allowing the company to carry on, even though they thought actually probably it was insolvent. So let me give you an example about how this might work, in practice. So imagine that your business is a seaside restaurant, but it then closes, or most of the staff has been furloughed. It has retained some staff because, for instance, it needs to maintain it needs to deal with some supplies if it can. It needs to make sure the building doesn't fall down. But it's got perishable stocks, can't really sell them to anybody. It's been able to pay its rent up to date, but it's not going to be able to pay the next quarter's rent unless it can be sure that it can carry on trading. It's got the option of taking out a business interruption loan that's available, but the problem with doing that is that the directors are unsure whether they can really afford to repay that. They might be able to repay it if they can open, but if they're not clear if they can reopen or business is going to be slow in the uptake after that, they're not sure actually whether they're going to make the position any worse. They certainly accept that the company would be insolvent if they didn't trade. This sort of scenario is an example that the government has given as to why it is that they brought the suspension of the wrongful trading in, because in those sorts of facts, a director might take the view that, well, if I carry on trading, then I could be at risk of a wrongful trading claim, claim personal liability against me, and so what I really need to do is close the business down. By allowing the directors to make the directors to make a decision about whether they can carry on trading, but without the threat of a wrongful trading, allows at least the prospect that the business can carry on. It's not a completely get out of jail free card for the directors, though, because there are still directors' duties that apply. Specifically, directors still have to act in a way that's most likely to promote the success of the company, having regard to the interests of its employees and fostering business relationships with suppliers, customers and others. Now, in circumstances where there's a furlough scheme that's currently in place, it's being tapered off and it's coming to an end in October, and there are obviously strains in the supply chain, bearing in mind that there are almost everybody in the supply chain is being affected by the pandemic. Decisions still have to be taken with those in mind. And nothing in the suspension of the wrongful trading rules, it seems to me, changes the general position, which is that once the solvency of the company is in doubt, the directors have to turn their attention toward the interest of creditors as well. There's no point feeling that you're cushioned from a wrongful trading claim if you're merrily carrying on trading in circumstances where there's absolutely no chance that the creditor position is getting much, much worse. Whether the pandemic's in place or not, the court may well take into account that trading has been disrupted because of the pandemic, but it doesn't remove the director's duties in those circumstances. There are some permanent changes as well. Significantly, there are 2 new insolvency procedures that have been introduced. One known as the restructuring plan. The second one is the standalone moratorium, which I'll talk about first. And there's also been a significant change on the restriction on supplier termination rights, which no doubt will be of interest to you. In terms of the moratorium itself, currently there has been a form of moratorium available for small companies that are proposing what's known as a voluntary arrangement, which is a form of restructuring arrangement which is done with the agreement of your creditors, which they vote on. There is also a moratorium that becomes available if you file a notice of intention to appoint administrators. There is no, or had been no, standalone moratorium until this act came into force. What it does is it allows the directors to obtain a 20 business day moratorium, which it will do by filing a variety of documents at the court. One of those documents is a document that's completed by an insolvency practitioner confirming that they are of the view that the moratorium would lead to rescue of the company as a going concern. That insolvency practitioner would then monitor or police the moratorium. The company then has a payment holiday during the moratorium for what's known as pre-moratorium debts. Now, pre-moratorium debts are any debts that fall due prior to the moratorium starting. It doesn't include debts that fall due after the moratorium has started, and it doesn't include, for instance, the remuneration for the monitor's remuneration. It doesn't apply to the to debts that fall due for the supply of goods and services during the moratorium, and nor does it cover rent or wages or redundancies during that time either. Most companies are going to be eligible for this. There are some exceptions, one being that if you've already been subject to an insolvency procedure in the last 12 months, this won't be available. But another one is that insurance companies, banks, financial institutions, etc., those sorts of companies, this moratorium won't be available to them. You've got some practical issues of dealing with a company when it's in a moratorium. First of all, unlike administration or liquidation, where an insolvency practitioner comes in and takes control, the directors are still in control of the company while the moratorium is in place. It's also, as I will come on to talk about, one of the trigger events, which means that the restriction on termination will come about. The company still has to pay for goods and services supplied during the moratorium. But some of your rights, as you would anticipate with the moratorium, are suspended. So it won't be possible for you, if you've got security, you won't be able to enforce your security. You won't be able to continue or commence legal proceedings. It won't be possible to exercise a right of forfeiture or to repossess any goods. You may be able to apply to court for leave to do that, but it seems to me that that leave is bearing in mind that the moratorium is quite short. It's not clear to me how likely it is that you would be able to get that leave. If the company was to then fall over, the debts that are incurred during the moratorium have super priority over any other debts in a later insolvency. The moratorium can last for 20 working days, but it is possible for that to be extended. So it can be extended by the directors for another 20 working days. So potentially you could have a moratorium in place for 2 months. It can be extended by creditor agreement by up to a year, although it seems to me unlikely that would happen. If you've got a moratorium in place for that long, you probably need some other insolvency procedures to be in place. But the monitor has powers to terminate. The most likely ground of termination is if the monitor considers that the company can't that the moratorium is no longer going to serve its purpose. So, for instance, the company is unlikely to be rescued in this process, or the company is unable to pay its moratorium debts. So, for instance, if it has a large debt that's due to a supplier, but there's no prospect of the company paying that, the moratorium could then be brought to an end, and all your enforcement rights would then resume, or potentially the company then goes into another insolvency procedure. Here's an example of where a moratorium might be relevant. Imagine a small trading company. It relies on debt. It relies on its income from its own customers, but it has a customer that has gone into administration, so it's suffered a very large loss. However, it's got a very strong order book. It's a sound business, but in reality, it needs an injection of funds. And what the director thinks the best way to do that would be to try and get a loan, and he will arrange that himself. But it's obviously going to take time to do that. So the sort of circumstance where he will go and speak to an insolvency practitioner goes along with his plan, and the insolvency practitioner thinks, well, yes, I think the company can be rescued with this, because if the loan is available, then he'll be able to pay off all of his existing, it'll be able to pay its existing creditors, and it will be able to carry on trading. So documents are filed, of course, moratorium is obtained, so that makes the creditors back off for the time being, and the company is able to pay its moratorium debts as it goes along. However, there's a snag. It was originally anticipated it would take 30 days to get the loan in place. In fact, it's going to take 50. That's more than 20 working days. And so there's another further discussion with the insolvency practitioner, who looks at the current position, still thinks the company is able to pay its debts. And so an extension is granted. There's no reason to go back to the creditors to seek their agreement to that. The loan is then put in place, all of the debts are then paid, and then the moratorium comes to an end. These are the sorts of circumstances where the moratorium serves a good purpose. If, on the other hand, the loan wasn't going to be available for 50 days, but was available for 70 days, wasn't available for maybe 70 days, or the insolvency practitioner wasn't satisfied that the company was able to carry on paying during that time. So, for instance, perhaps its wage bill was getting higher, or because further customers weren't paying, the monitor would then have to make a decision about whether to pull the plug and to end the moratorium. Something which isn't very clear is, because although there has been a moratorium in place for small companies for where they were proposing voluntary arrangement, it was actually very rarely taken up. And an issue I can see here is that, because you do need an insolvency practitioner to be satisfied that the company can not only be rescued, but also that it's capable of paying its debts during the course of the moratorium. It's not clear to me actually how often we will see one of these, but certainly for smaller companies, it may well be something that is looked at, particularly for short-term solutions. Another new insolvency procedure is what's called the restructure plan. There is currently a form of restructure available in the Companies Act known as a scheme of arrangement. We see it for more complex restructurings, but it has limited, its effectiveness is quite limited. And one of the reasons for that is because in order to get one of those passed, you need to have approval from each different class of creditors. And if one class of creditor objects to that, even if they are out of the money, the procedure, the restructure won't go through. What the Act has changed is that it will now be possible for a scheme of arrangement to be passed, even if one category of creditors doesn't agree to that, provided that dissenting class wouldn't have been any worse off. So it will be possible now for those creditors to be what's known as crammed down. And that would hopefully be that hopefully allows a very larger restructure to then take place that might not otherwise have happened. We think in relation to these sorts of restructuring, you're more likely to come across one of these in the context of maybe a very large group of companies, or akin to a Carillion or a Thomas Cook type restructure. But again, we don't really know at the minute how many of these you might see, but this is certainly something that's very new, and it will be certainly looked at and probably become more common for larger restructures. The big practical change that people are going to see is the restriction on termination rights. For as long as for as long as contract law has existed in this country, we've had a principle that the parties are basically free to do or free to agree what they like. A concern that has always been at the forefront of the insolvency profession is that if you have got a key supplier, the rescue of the business may well hinge on whether or not you can keep that key supplier on board, and the ability to terminate or to basically act or demand ransom payments can be a challenge. What the Act has done is to render ineffective any clause that provides that the contract will automatically terminate on an insolvency event, or that any other thing would happen automatically on an insolvency event. And it will also prevent a supplier from exercising a termination right, or to do any other thing which is triggered by an insolvency event. So it's not just termination, but any right that allows you to vary the terms or to change the contract price or to demand further payments. All of that will be stopped. It only works one way, in the sense that it's only the supplier that can't do this. That obviously can be complicated in circumstances where you've got a chain, because it may well be that you've got more than one supplier in the chain, and potentially you may find that a supplier who's right in the middle of the chain may find that they may find that they're not in a position to terminate, but somebody else in the chain is. An additional restriction is that if there's a termination right which had already existed before the insolvency event starts, if that right hasn't been exercised by the time the company enters an insolvency process, that right effectively is suspended. So it won't be possible to exercise the termination right for the period that the company's in the insolvency process. That could be a moratorium, but it could also be administration as well. How can you get around these? Well, you can ask the company. If it's a moratorium, you can ask the company if it will agree, or you can ask the administrator or liquidator, but it's more likely to be an administrator in these circumstances, whether they will be prepared to agree to you terminating. There are some exceptions. There is a further exception to that, though, which is that if the company or the office holder doesn't agree, you can apply to court for an order permitting you to terminate or exercise any of those rights, if continuation of the contract would cause you hardship. There's no real detail in the Act about what that means. We think what it's likely to mean is that if continuing to supply in circumstances where it's not clear whether you'll be paid, it will cause you a solvency problem yourself. That's probably the sort of thing that we have in mind. The court would have to balance up the benefits of the company and the creditors and allowing the continued supply as against the ability to or the financial impacts that you would have on complying with that. The Act doesn't give you any. It doesn't give the company or the office holder any requirement to guarantee any payments. And so again, this is something which is new. So it's a developing area. There will, however, be a temporary exclusion until the 30th of September 2020 if the supplier is a small company. So you are a small company for these purposes. If you have turnover, if you have fit 2 out of 3 of the following criteria, which is you've got turnover of 10.2 million or less, you've got balance sheet of 5.1 million or less, or you employ 50 people or less. Paul is now going to talk to you about what impact that has on your drafting and what options you might have to get around some of these.
Thanks, Lino. Yeah, so with that context of what the legislation says, I want now to focus on the practicalities and drafting points to consider for contracts going forwards. I'm going to talk for about 10 minutes, and so we will have time for questions at the end, so please do submit your questions using the Q&A function. But Lino's just explained how a customer entering into a relevant insolvency procedure substantially limits the supplier's ability to protect its position. So as a supplier, you will want early warning that a customer is experiencing financial problems. And a couple of things you can do to try to get that early warning are: 1, tighten the payment arrangements under the contract, and 2, impose financial information reporting obligations on the customer. To achieve the tighter payment structure, you can look at requiring payment or part payment in advance. And similarly, if you would traditionally invoice any large sums upon completion, if the nature of the contract suits, you could divide those larger sums into a series of instalments payable at certain intervals, for example, monthly billing, or upon achieving particular milestones. A couple of other ways to tighten payment arrangements are to shorten the payment period. In the current climate, I would certainly be looking to avoid accepting anything longer than 30 days from the date of invoice. And you can also shorten the remedy period for non-payment before rights to terminate or take other action arise. It has been quite common for a party in breach of contract to have, say, 30 days to remedy the breach before a right to terminate can be exercised. If that is the case, then if invoices have to be paid within 30 days, your invoice can go unpaid for 60 days before you've got a right to terminate. And in those 60 days, the customer may have entered a relevant insolvency procedure, cutting across your contractual rights, which as a supplier is what we're trying to avoid. And another potential source of the contractual protection for suppliers, as mentioned, is to impose financial information reporting obligations on the customer to help the supplier assess its solvency. The type of information we're talking about here could include information about the customer's financial status, such as its credit rating, and reports on the customer's payment of invoices under other contracts, subject to any relevant confidentiality obligations. Various public sector organisations have to publish the percentage of their invoices paid within 5 days and paid within 30 days. And it is that sort of information that suppliers could now be looking for from other customers too. This type of financial information can inform other contractual rights. For example, if the percentage of invoices being paid within 30 days drops below a certain threshold, that could potentially trigger a contractual right for the supplier to restructure its payment terms, or stop supply, or terminate. I'll move on to termination rights in a moment, but just before I do, I want to flag that if you're drafting or reviewing contracts on behalf of a supplier that is supplying goods, make sure your retention of title provisions can be exercised pre-insolvency. And I say this because historically, retention of title clauses have sometimes been drafted to trigger the right to reclaim the goods that have yet to be paid for by the customer on the customer's insolvency only, which is even less helpful than it used to be given the new legislation. And I appreciate, by the way, that it will probably be easier to get these types of protection, particularly with the tighter payment structure and financial information reporting included in new contracts not yet entered into. But that doesn't mean this isn't a conversation worth having with customers that you've already contracted with. After all, if an existing customer objects to tighter payment terms or to providing greater transparency about its financial situation, they may be a customer at risk of insolvency. And so that objection in itself may be an early warning sign that makes you consider options for reducing your exposure under the contract with that customer. Moving on to drafting termination rights themselves. We can get rid of that. We're clearly looking for rights that can be exercised before a customer enters any relevant insolvency procedure. A right to terminate for convenience can be exercised without needing a trigger event, and so it is top of the list. It would enable the supplier to terminate upon getting a whiff of financial difficulty from the customer. But any such termination right is likely to be resisted by most customers, because if their suppliers could terminate at any time without having to justify the termination, then the customer may be left short of key goods or services, even if it is perfectly solvent and it's done nothing wrong. Commercial reality means suppliers generally won't want to terminate an agreement with a customer who pays for goods or services, but I do think this type of termination right won't often be agreed to without some negotiation. In contrast, it is harder for a customer to argue against the supplier having a right to terminate the contract if invoices remain unpaid. So as a supplier, you should ensure that you have a right to terminate for non-payment. And I've included on the slide an example of the type of wording to cover this. The right to terminate for financial distress usually involves a more subjective judgment, as shown with the example wording on the slide. And therefore, customers may try to resist giving suppliers the right to make the call on when the customer is in such financial distress that the right to terminate is triggered. As I mentioned, if you're getting regular reports on the customer's financial situation, then that information could be used to create a trigger for termination rights. But it is important as a supplier to avoid being totally at the mercy of the customer's accuracy of reporting. And because of that, if you've got a right to terminate if the percentage of invoices being paid by the customer within 30 days drops below a certain threshold, it would be preferable to supplement that with a broader right to terminate if the supplier can justify the opinion that the customer's financial position has deteriorated to such an extent that its ability to pay for the goods or services being provided is in jeopardy. we can move the slides on, there we go. Of course, as lawyers, we all know that even the most carefully drafted contracts need good contract management. And the rights we draft and negotiate are only really of any value if they're used as intended. So there are various practical steps that suppliers should be taking to protect their position under their customer contracts. These include conducting due diligence on customers' financial position before entering into contracts. And if there are substantial concerns about a potential customer's financial situation, it might be advisable not to enter into the contract unless you're receiving payment upfront. You should actively monitor customers' payment performance and financial position during the contract to get earlier warning of likely difficulties, and ensure invoices are paid when due, and if necessary, tighten debt collection procedures. For example, I'm getting weekly reports on the invoices yet to be paid on My Matters Here, which helps me make informed decisions about how much exposure to accept with particular clients. And your organisations do need to be prepared to exercise contractual rights to stop supply or terminate promptly when those rights arise. If you delay and the customer enters into a relevant insolvency procedure, then you'll probably be left at the mercy of the court, the company, or the office holder, as Lino was explaining, should you then want to terminate. Okay, we'll turn to your questions about these issues in a moment, but just before we do, while some of you are typing away in the Q&A box, please can I just flag the upcoming webinars that my partner Jagvinder Singh Kang is running to discuss the implications of the recent European Court of Justice decision in the Schrems II case for organisations that have personal data held and processed outside the European Economic Area, which has relevance for us all in the UK in light of Brexit. As the slide says, the ECJ judgment affects more than just transfers of personal data to the US. Jagvinder will be talking about this tomorrow at 10 a.m. and again on Tuesday, the 4th of August next week at 4 p.m. And further details about this and how to sign up can be found on our website on the events page. Right. Lino, what questions have you been seeing whilst I've been talking?
Okay. I've got a question about whether restrictions on termination rights apply to leases. Well, the short answer is that those changes I've talked about don't apply to leases, but that's because there is already a restriction on being able to exercise a termination right in a lease already. So termination of a lease is known as is known as a right of forfeiture, and you will see those. You'll see those in routinely put in a lease. When a company becomes subject to a moratorium, or indeed any other form of insolvency process, then the right to although that will be typically seen as a forfeiture event, it's a right that can't be exercised except with the consent of the administrator or the company that's in a moratorium. If it's said whether or not that consent's given largely depends on what the company will needs to do with the premises. And typically speaking, if the business is being sold, or the company's needs to trade from those premises, it won't be possible to exercise the right of forfeiture at all. But the quid pro quo for that is that rent will have to be paid. If the question is, do the restrictions on termination rights apply to a license? I think that is a different question altogether, because the restriction on termination only applies to contracts for goods and services. And there was a question, there were some question marks at the beginning about whether or not these restrictions would apply to licenses, whether that would be a license to occupy premises or a license, an intellectual property license or anything like that. And it doesn't seem that they do apply to those. So it does appear just to be limited at the minute to supply of goods or services. But I mean, as I said, these are early days, and it may well be looked at. But certainly for some companies, an intellectual property license or an ability to be able to trade from a premises are, even if that's under a license rather than a lease, may well be key. So I would suggest watch this. I would suggest watch this space. Another question we've been asked: does the Construction Act rights override these new provisions for suspension of termination in the event of non-payment? That's a good question. I think the short answer is that it doesn't override, and that your ability to terminate, well, certainly rights of suspension, it seemed to me that if they are triggered by an insolvency event, then a right of suspension is not a right of termination, but it might fall into the it might fall into the a provision of a contract providing that something else happens on the event of on an insolvency event. But it also, it's certainly not a right of termination that could have arisen pre insolvency, and that's one of the things that that is one of the things that the Act is there to stop. If you've got a pre-existing right to terminate, that right will be suspended if you haven't exercised it. And it doesn't seem to me that that is necessarily overridden by the fact that you've got other statutory rights. Although I have to say that there have been a multitude of decisions recently about the interaction between the statutory right of adjudication and the ability to be able to collect a liquidator to be able to collect debts in, and that has been very fluid. And I'm pretty certain that certainly in the context of construction contracts, where you've got again large chains of contracts in place, I'm not sure that necessarily that there would have been any thought given to the interaction between those rights and the termination rights. As a supplier, does the small business exclusion until the end of September mean an SME can still terminate the contract if the client goes into an insolvency or moratorium? I think the answer to that is, will be yes, because it's provided you fit that category, you fit the definition of under 10.2 million turnover, 5.1 on your balance sheet, and less than 50 employees. The termination restrictions won't, you'll be able to exercise those rights certainly until the end of 30th of September. But what I would say is that they've provided in the Act for the ability for that date to be changed. So originally, these restrictions, when they were in the bill, were only being talked about as being in place until the end of June. We also know that the date that for the restriction on enforcing any rights of possession you might have was also going to be until the end of June, and that's now been kicked back until the 30th of September. So it's quite possible we might see this go on. And I suppose something that we do know is the furlough scheme is still going to be, it's tapering off at the end of August and is coming to an end in October. It may well be that we see the 30th of September date get pushed back a bit more, but we'll see. We don't know.
Shall I pick up another question, which is where we are the customer and our existing contract has a mutual clause allowing termination by either party for insolvency, should we just leave it in place on the basis that we will still be able to use that right, even though the supplier won't be able to? So there's no need to vary. And I think the answer to that is, if you are the customer, yes, you do not need to worry in a way about amending termination clauses. You are getting protection of this legislation. It is for the supplier to worry about seeking to vary termination rights to give themselves more options in their contracts with customers. Then there's another question about whether the new legislation impacts on the discretion contracting authorities, so that's public sector organisations essentially, have to prescribe the financial standing suitability requirements that they can prescribe in ITT selection questionnaires under the Public Contracts Regulations 2015. And I think the answer to that is this legislation does not impact on selection questionnaire arrangements, selection questions under the Public Contracts Regulations. Then there's a question about whether financial or insurance related contracts are excluded. And it is right that financial services contracts are excluded from the scope of this legislation, or this new right to terminate, at least. It applies to all contracts for the supply of goods and non-financial services.
It's probably also just worth pointing out that the way that financial contracts has been defined is it also includes a loan as well. So one reason that we were a bit sceptical about how well the moratorium will work is that it's still possible for, although you can't issue proceedings or enforce any security, you could in theory call in a loan, or call or demand repayments of sums under an overdraft, because that still seems to be caught. But financial or insurance related contracts are excluded from the termination, and they're also excluded from the moratorium as well.
There's a practical question that's come in. Apart from asking a client for financial information, is there a way to monitor if a company is in financial distress? For example, is there an online database which records this information? And it is possible to do credit searches. So the likes of Experian and others provide credit information on organizations. We use that when doing our due diligence on our clients. Lino, have you come across any other?
Yeah, so there are searches that can be done to find out if the company's entered an insolvency process. So if a company's filed a notice of appointment, a notice of intention to appoint administrators, or has appointed administrators, or has gone into compulsory liquidation, or there's a winding up petition that's been presented, that's the sort of information you can get by doing a search at the court. And there's a particular inquiry line that they have, where they'll run that search for you and see if anything comes back. We're anticipating that same search would also pick up whether or not a moratorium has been obtained. But what you won't necessarily be able to pick up is that those aren't the only forms of, not every single form of insolvency procedure will involve filing documents at court. So for instance, if you are if a company is proposing a voluntary arrangement, or is considering placing the company into liquidation, but by a resolution of the shareholders rather than a creditor presenting a winding up petition, you wouldn't necessarily find that information out unless you were given that information by the company, or by an insolvency practitioner who was engaged by the company to do that. That you should get that information as a creditor, but if you're making a decision about whether to contract with somebody, of course you won't get that information, and you're just basically left to credit searches. But the trouble with that is that they're always based on relatively old information.
We've come up to 10:45, and we don't want to keep people on beyond that. There are some other questions that we haven't had time to answer, and so we will follow up on those questions. If people who've asked them anonymously would like to email Lino and me afterwards, that's great. We can then respond to those questions. And I suppose just to finish, we're always grateful for feedback, and if you'd like to comment on how you found this webinar and any particular topics you would like to hear more about, please use the Q&A box again to tell us. But otherwise, thank you very much for attending, and we'll draw this to a close now. Thank you.